Hi, I'm Nikki Aston.
And I'm Stephanie Kyriacou.
And we are associates in the family team in Nottingham and Leicester respectively. So we thought it might help to tell you a bit about what we do and walk you through the areas where we can advise clients. So the main area of our work is helping people through relationship breakdown. And from that, there are different offshoots such as divorce, finance, children, civil partnership dissolution, domestic abuse and property disputes. We can also help clients with living together agreements and prenuptial agreements.
So Nikki, when clients first come to see you, what do you tend to advise them about the length of time for the divorce and also the approximate costs of the divorce proceedings themselves?
Okay, so because of the year we've had and there's such a burden on the courts at the moment, divorces are taking longer than they normally would. So we could be expecting about a year for that from start to finish. And that also depends on the finances. The cost is £550 for the court fee, and you have to pay that whether you're instructing a solicitor or not. You have to choose a ground for divorce. There's 5 of those, and we would advise which client which one would be most appropriate for them. And roughly, it's basically getting the papers issued at court, getting to the point of decree nisi, and then once finances are resolved, it's bringing that to a conclusion for decree absolute at the end. So Steph, in terms of the finances in divorce, how would you advise clients on how they can be resolved?
Yeah, so as you know, Nikki, each case is on its own merits. So what's going to be right for one divorcing couple won't necessarily be the same for the other. But very briefly, there's various different routes to resolving financial matters on divorce. At the cheaper end of the spectrum, you've got where the parties are able to have direct negotiations between each other. Another alternative is attending mediation, which you can touch upon later on. A third option is the traditional route of full and frank financial disclosure between solicitors. And then at the very worst case scenario end, you've got obviously court litigation, so applying for a financial remedy order and having the courts determine how the finances should be resolved upon divorce. Do you want to just tell us a bit about how mediation can help the parties?
Yeah, so mediation can be used alongside the divorce and financial process as that goes through the courts. It is a voluntary process for the parties, so if it's not working, they can stop at any time. The mediator is impartial, so they're not there to make the decisions for the clients, but the clients have control as to the eventual outcome. So it's better for them to feel that they've had ownership of their process and had some control with it. Overall, it is cheaper than sticking with a normal route of litigation, and it is encouraged by the courts as a different way of resolving matters, and it is expected that people try mediation before they do head to court in any event.
Brilliant. And also a lot of questions that I get asked from clients is whether mediation is legally binding. So do you just want to cover that one as well?
Yeah, so it isn't. So if people do get to a point where they have reached an agreement, what they would do then is go back to their solicitors with the proposals and say, is this going to work? Can it be put into a court order to be enforceable? And if so, then that solicitor can draw it up into a consent order at the conclusion of the divorce, which is binding, and then that reflects the overall final financial settlement between them.
Brilliant. Another question that crops up frequently with my clients, Nikki, and I'm sure with yours, is how do you resolve financial matters where, for example, the former matrimonial home is owned jointly by the husband and the wife, and then also, say, for example, the husband's parents as well? How do you go about trying to resolve that sort of family dynamic?
This is something that has come up more than you'd think, actually. So I have had a few cases where the party's parents have been involved. They've got a financial interest in the property, and that can be very complicated as to trying to sort out who is entitled to what. So sometimes the parents have to be joined as party to the proceedings. The court has to look at everyone's overall input, their contributions, etc., and what everybody needs in terms of going forward, in terms of housing needs and things. So it's difficult to involve parents and things in mediation because sometimes the power balance can be too much, the dynamic can be too complicated. So inevitably those ones do end up in court, but it can be done. And certainly we've had satisfactory outcomes when we've had to deal with those sorts of cases. Okay, Steph, we've spoken about finances as part of the divorce. Do the courts deal with arrangements for children as part of the divorce at the same time?
So that depends really. The children side of things are completely separate to the divorce and financial matters. And the courts will only get involved if the parties aren't able to reach an agreement about the children themselves. So 9 times out of 10, the parties are able to put their differences with each other to one side and reach an agreement that's going to be suitable for the children of the family. In the situation where the parties can't agree, then it's open to either party to make an application to the court for the court to decide what should be best for the children in terms of where they should live, how much time they should spend with the other parent, for example. Once an application's issued, the court will determine whether it's necessary to appoint a social worker, known as a CAFCAS officer, to help the court determine what the arrangements for the children should be. So yes, the children side of things are completely separate to the divorce and finances, and it's hoped that the parents can sort those out themselves, but if not, then we can obviously advise and assist clients in relation to an application should that become necessary. We've talked now about the divorce process, the different routes to resolving financial matters, and we've also touched a little bit on the Children Act matters. But what happens, Nikki, when couples aren't married? Can you tell us a bit more about, for example, if parties are just simply living together and then separate?
Sure. So one thing that we always tend to hear when people come to us in these scenarios is they think if they've not married, but they've been living together for a long time, that confers what's called a common law marriage rights upon them. So they'll think they've been living together for 20 years and then automatically have rights on the other person's property. And that's not true. And that's the first thing we always end up telling people. And obviously that can have implications. If a property is owned in one person's name, the other person has no rights at all. So this tends to be quite a difficult area, which does have some overlap with our civil litigation as well. And basically it's advising clients that whether they've put input into the property, whether they have beneficial interests in that, whether it's worth them pursuing that under what's called a Trust of Land Act application. And that is quite a difficult area because the law is it's uncertain and it depends on the specific facts of that case. In terms of children, there is another application we could make called the Schedule I Children Act application, which can provide for properties to be provided for children during their minority, and also lump sum payments too. They're not very common applications, but they do exist, so it's worth identifying those in those cases where we do have clients who aren't married. So we have spoken a lot about the work that we deal with after things have happened for clients, but we do preventative work, don't we, Steph? So what can clients do to prevent these things happening, and the sort of advice we can give?
Yeah, so certainly we can assist clients with things such as living together agreements, and you may have heard them called cohabitation agreements. We also advise and prepare prenuptial agreements, which I'm sure is a familiar term for most. However, not many people know that we also prepare postnuptial agreements. So it does, essentially what it says on the tin, it's a nuptial agreement that's entered into after marriage. So pretty much same sort of content as what's contained within a prenuptial agreement. But if you didn't get round to doing your prenuptial agreement, and obviously you've gotten married, but then have subsequently decided, actually, I do think I need to have something in place for the worst case scenario, then we can assist parties with postnuptial agreements as well. So clearly nobody enters into a marriage expecting it to fail. But with the sad reality that over 42% of marriages will end in divorce, with a statistic like that, most clients are grateful to know about the options available to them in safeguarding their assets in the event of relationship breakdown. So if one way to try and give your clients some sort of further knowledge in this area is like treating a pre or postnuptial agreement like an insurance policy. Hopefully you'll never have to use. So we can assist clients with all of those things, and I'm sure you're the same, Nikki, but we're quite happy to have a free initial conversation with any clients that are having these sorts of issues or just want to talk something through with us to see if we can assist.
Absolutely. So we're always here and happy to have our details passed on, and hopefully we can help people who might need it.